Good morning, everyone. Today is April 4th, 2024, and welcome to the latest installment of the New Possibilities Hour, part of the Will Work for Food project founded by Natalie Armstrong Motan in 2020. Every week, Jean Lawler and I host another cutting-edge webinar for mediators, arbitrators, lawyers, and everybody who negotiates. As you know, there's no charge for these great webinars. Rather, we ask you to contribute to a food bank if you like what you see. And since we began week in and week out, our audiences are so generous in contributing in honor of our great speakers. One of my favorite parts of the webinar every week is when we announce the running total of just how much our generous audiences have contributed. Jean Lawler, would you please do the honors?
With pleasure. Well, everybody, you know, I've been targeting 550,000 since we hit the $500,000 mark. And today I am so happy to say that we have exceeded that $550,000 number. So 600,000 is our new target. $555,023.82 is what we've been told about so far from people. And so we do need you to tell us what you've donated or contributed. If you'd be so kind, we'd be happy to add it to our running total. Thank you so much for your generosity.
Thank you, Jean. That's fantastic. And thanks to everyone who has contributed and everyone who has spoken. Today, we have another fantastic presentation for you on successful strategies and mediations with insurance coverage issues. Presentation will discuss strategies for how to prepare for and conduct mediations in cases that involve insurance coverage. We will also discuss a few great examples of what not to do based upon real past experiences, and hopefully none of those experiences will sound hauntingly familiar to anyone participating in this webinar. We have a tremendous presenter today. Jamie Carsey is a senior managing director and head of litigation at Markel Insurance, where she oversees and manages the in-house coverage counsel division, the in-house attorneys who handle the extra contractual claims and lawsuits against the company and claims compliance. Jamie also oversees all insurance-related litigation against the Markel entities in the United States. She also provides training to the claims department on coverage and litigation issues and assists underwriting with drafting and revising policy language. Before she joined Markel, Jamie was an equity partner with the law firm of Thompson, Coe, Cousins, and Irons, where she was the vice president of the insurance coverage practice group. Her practice focused on insurance coverage matters, breach of contract, and bad faith litigation, including trials in multiple jurisdictions. So, Jamie, we'd love to hear a word. Well, first of all, welcome. We'd love to hear a word or two from you about the food bank to which you would like people to contribute if they're able. And then on with your presentation. The floor is yours.
Thank you. Thank you so much, Jeff and Jean and Natalie, for having me and for this wonderful forum that's giving back and helping out individuals and families with food insecurities. I think this is such an incredible platform, and I'm really, really honored to be a part of it. I am donating today to the Houston Food Bank. I am in Texas. You might hear me drop a few y'alls as we go through this presentation. But would love it if you would contribute to the Houston Food Bank, but any food bank that speaks to your heart or is local to your community, obviously, would be a welcome donation and contribution. So thank you. Well, if we're ready to get started, let me give, we're all mostly lawyers on the call and mediators and ADR folks. So let me give my disclaimers. My first one, of course, is that the opinions that I have today are just my own. They're not necessarily the opinions of my current or former employers or really anyone I've worked with. You never know what reasonable minds may disagree. Also, these things that we're going to talk about today are obviously not going to apply in every case. You have to approach these on a fact-by-fact, case-by-case basis, but I definitely have seen some interesting things over the years and do have some perspectives that I am excited to share with everyone today. So I want to start, start at the beginning, I think is always a good place. And for me, the most important thing for a mediation, and sometimes I think in our busy lives gets a little bit lost, is preparation. I really cannot emphasize to lawyers, to the parties, enough how much they need to be prepared to attend a mediation. A lot of us have very busy dockets. And sometimes we can be like, oh, we have this mediation today. But it's really important to be sure that you are taking a step back and getting yourself, your party, as prepared for that mediation as you possibly can. The mediator obviously is going to read all the things that you provide, but you want to set that situation up for success. You don't just want to dump every summary judgment, all the summary judgment briefing on a case on a mediator necessarily the night before the mediation. You really want to be thoughtful about how you're going to be prepared for the mediation and how you want to prepare the mediator. So what I mean specifically is I really believe that a well thought out mediation statement is important. And that may sound like, duh, of course. But I don't know that everyone is doing that. I think a lot of times they are just dumping like a summary judgment brief or something on a mediator, or it's just a fully advocated position that is a little far off from reality, possibly. I think it's better for the purpose of a mediation, if you really want a real chance of settling your case in a way that's favorable to your client, you really need to give the mediator the tools to do his or her job and give them that in that mediation statement. With the lens of what if you're in a case where you have an underlying tort claim or a contract claim or something like that, and then there's also a coverage issue that is involved in that case. So you have an insurer kind of behind the scenes that is controlling the settlement money. And if you're in that situation, it's really important that the coverage folks are prepared and ready to attend that mediation and to provide insight to everyone as to what's going on with the coverage part of the case. So I often recommend that the coverage lawyer or the claims handler also provide a separate mediation statement to the mediator to outline the coverage issues. The mediator on this call, I know Jeff very well. He's great at coverage. Not all mediators are great at coverage. Some of them are like, oh, glassy eyes. This is boring. But you definitely need to educate them on what is going on with the coverage part of the case so that they can be up to speed, because that's the driver. That's the money. That's going to make or break whether or not the case gets settled that day. So if they don't understand what's driving that, it's going to be a much harder day at mediation. So I definitely want to emphasize for my coverage folks on the call to be sure that y'all are getting prepared and preparing your mediator in advance. And this is critically important when the coverage issues are driving how much money you're going to bring to litigation. So if you're defending the case because you have a duty to defend that's triggered, but you don't think you have any indemnity, in other words, you're not really going to be paying for the judgment and you're not really putting money into the settlement. Let's say you're coming with little to no dollars to settle that case. You got to tell somebody. You can't just show up and be like, I'm here for lunch, but I don't have any money. Get people prepared for that in advance so you're not just dropping it on them. A lot of times the fact that there are coverage issues in a case can help solve or resolve a case at mediation, because the plaintiffs are like, okay, I see where this is going. That's an ugly, long, complex coverage battle that I'm facing down the road. I'd rather just take what I can today and get that money in my client's pocket and move on to fight something else. So it's not always a hindrance. Sometimes it can really help clarify things and get everyone on the same page and help you get that case resolved if you're able to be prepared and you have the mediator prepared for that and you're just not dropping that bomb in the middle of the mediation. Even if we're not talking about coverage matters, I really want to emphasize to parties, to lawyers, and if you are like an in-house attorney or a claims handler that's attending a mediation, you really need to be prepared. Because mediation is a negotiation. It is a back and forth. So the other party is going to come to you with a new argument you haven't heard before. They're going to give you new facts that you haven't seen yet. And you need to be able to respond to that in the moment. And if you don't really know your file very well, that's going to be harder for you to do. So it's really important that you understand what are your main points that you want to push. Where, if someone comes to you and they're like, oh, we now have these new damages, you should be in the back of your mind thinking, no, that's not right, because I've already seen this over here. That should take care of that issue. But if you can't push back in that moment, you're going to lose that momentum. So know your file, be prepared. Again, I know a lot of attorneys, a lot of insurance claims people, a lot of risk managers. You are busy folks, and I understand. But when you're going to mediation, you really, if you know your file, you're going to have a much better chance of negotiating that effectively than if you're, moving through your papers or you just don't know. So you kind of have to call it a day so you can go back and regroup. It's better to just know the file as much as you possibly can in order to be prepared for those moments. I'll pause here for a minute for the mediators if you all have any thoughts or examples on preparation and or lack thereof that you want to add.
Well, Jamie, I'll ask a question. You talked about preparation, excuse me, with the mediator. What about the coordination between coverage lawyers and defense lawyers, the people sitting shoulder to shoulder on the defense side of the table? How do you view that? Particularly in a situation where a case is being defended under a reservation of rights.
I think that's a really good point that you raise. I think, on some level, you have to keep those things separate. So you want to, perhaps the file is split within the insurance company. So you have a different set of claims people handling the defense file than the coverage file. And that's fine. But there should be some discussion about, what is potentially going on. You don't want to put the defense lawyer in a bad position. They should not be dealing with coverage issues or arguing coverage issues. You really want to try and make it clean for them so that the coverage lawyer, the coverage handler is there handling the coverage questions, and the defense lawyer and the defense claims handler are there handling the defense issues. I often encourage in some situations for an insurance company to split the file, or if they're not totally split, to have separate people attending at least the mediation so that the defense person can really focus on the defense and liability issues for the insured, and you're arguing that piece. And then you have the coverage folks that are over here and they're focused on and they're arguing the coverage side, all of which to reach the appropriate resolution with the third party or the plaintiff in the case. So you're working together towards a common goal of getting the case resolved, but you're doing it from sort of separate avenues and separate corners a little bit. But I think it's important to just be aware that is happening and be sure that the mediator understands kind of what the coordinated efforts are so that they know kind of who's who in the room. And I think the plaintiff should know that as well, so that they understand these are the coverage people making the coverage arguments, and then these are the defense folks and they're handling the defense of the file. I think it's important to be clear on that.
And Jamie, this is Jean. Oftentimes in those situations, it's the coverage side of things, the coverage attorney and the coverage claims rep who have the money and who are really controlling the settlement and the negotiations.
Yes. And it's important that people understand that, right? Because plaintiffs can get very, and it can get very frustrated because they may have this really great case, but if there's not coverage for it, if there's not really an avenue for recovery, that's difficult for them to understand. And so the more you can kind of get them to understand the reality of that situation, and that's where a mediator's role is very important, to come in and be like, look, this is just the way of the world, and you can recover against this insured, but they have nothing. And if you want anything from the insurance company, now is kind of the time to get it, because they're looking at it from cost of defense or whatever perspective. And I also really appreciate if you are a mediator that is not really savvy when it comes to coverage and you're dealing with a complex coverage issue. A lot of times mediators would just let me as coverage counsel go into the plaintiff's room and kind of talk them through it. And I thought that that was always very helpful. And then the mediator could come in afterwards and kind of work the room a little bit. But it's always nice when the plaintiff is maybe hearing about this for the first time to kind of have a sit down with coverage counsel and be like, let me walk you through the policy. Let me explain to you how this works, so that they can kind of start to get their head around what is happening on the coverage side, which is not usually their initial focus. So I think those are good points when you've got complex coverage issues that are kind of driving what's going to get paid on the defense of a claim.
Jamie, I agree with you that oftentimes it's very effective when a representative of the insurance company, kind of the new kid on the block, goes in and talks to a third-party plaintiff, a tort plaintiff, about the realities of coverage. Because after all, that coverage lawyer has not been the one knocking heads with people. It's not been the one creating antagonism in depositions, discovery, and all the rest. Yet I find many people from insurance companies are reluctant to have those face-to-face conversations, claiming that it might somehow expose them to some sort of bad faith exposure or it's unseemly in some other way. Can you comment on that for all of those insurance in-house people, claims professionals who maybe need a little help getting over that reluctance?
I can. I think in a lot of instances it's really fine. And as I said before, it's a good idea to sit down and explain that situation. I mean, if the shoe's on the other foot, essentially you're asking the plaintiff's attorney just to take that there's no coverage or little coverage at face value, and that's going to be difficult for the plaintiff or for their clients. I think it only makes sense to want to walk them through that. They kind of want to walk through and understand that. I think it was maybe a little bit easier back when we felt like mediations were more confidential. I think now the mediation confidentiality is kind of opening up a little bit. I'm sure y'all can have a whole other podcast on that and have. But even still, even if what happens in the mediation doesn't necessarily stay in the mediation, in a lot of instances, I think it's fine for a representative of the insurance company or their coverage counsel to go into the plaintiff's room and sort of explain what is going on. Now, in a lot of states, there's no privity between the plaintiff and the insurance company. There's no duty for an insurance company to do that or explain anything. They don't owe anything to a plaintiff before there's a judgment or settlement, but it might help get you across the finish line if they are able to have an understanding. Now, look, are they going to be like, that's a great point, we'll just go home? That's not going to happen, but at least they start to understand what these issues are, that they're serious issues, and they start to see that road in front of them. And that they need to appreciate that and explain that to their clients.
So let's circle back a little bit on the preparation point. You talked about people having preparatory conversations with each other. Sometimes you're in a situation as a carrier where you think it would be reasonable and appropriate for a policyholder to contribute to the settlement. Let's say there's potential or negligence. What sort of preparation do you do, Jamie, to brace the policyholder for the possibility that they may be asked to contribute to a settlement?
You broke up a little bit for me, but I think the question was when you might be in a situation where the insured might have some individual exposure outside of the insurance, when or how should an insurance company reach out to that policyholder in advance of mediation and kind of have that discussion? Was that okay?
Yes, yes.
That's an excellent point. So I think it's important to do that earlier on, in advance of the mediation, depending on how much money you're asking for an insured to contribute and the size of the insured, right? So you have to sort of ask yourself, is this going to be like a big ask, or is this going to be like a, oh yeah, okay, I might have that in my back pocket right now type of an ask, depending on your insured. And so once you have, once the mediation gets set, or when you start talking about mediation, if you've already got your coverage issues out there, you already have your reservation of rights, you've had that discussion with the insured about, you know, hey, look, we're defending this, but we think these things are not covered. And if that's really where this goes, then that's going to be on you. Hopefully you've already had those conversations with the insured. So when you are starting to talk about mediation, when you come to them and say, okay, so if we want to get this done, we suspect it's going to be, we're going to get it done around X amount of money. We'd like for you to contribute, you know, whatever amount or whatever percentage. I think you, if you're in the situation where the insurance company is the more sophisticated litigator, you know, you do this more maybe than your insured does, then I would recommend maybe just proposing a split, you know, what you think the split should be based on the coverage issues, proposing an amount, kind of starting that conversation as opposed to saying, what do you want to contribute? Now, if you have a ongoing account or a sophisticated insured with like a risk management team, then maybe you let them start the discussion. But I do think you want to have that well in advance of the mediation, that they can be ready and prepared for whatever money they're going to bring. And look, there might be some disputes on that back and forth, right? So you want to give that some time to percolate. And so by the time you get to mediation, y'all have sorted yourselves out and you're not spending half the mediation on that. And you come sort of as a united front, ready to try to get it done. That's best case scenario, I think. Not always able to be achieved in every file. But again, I think the critical foundation to those discussions is that the insured understands your coverage opinion. May not agree with it, but you've had those conversations about why you see this as potentially not a covered claim at the end of the day, or partially not covered. And you need to have those conversations along the way with the insureds, I think is helpful, in order to, you know, come to them to ask for contribution at mediation. Sometimes files don't lend themselves to that. Things come up last minute. But again, best case scenario, you kind of get primed for that, and then you have plenty of time to discuss it before you mediate.
Well, and Jamie, this is Jane.
Go ahead, Jane.
Wouldn't you find that in those cases, generally there's coverage counsel involved, probably on both sides, for the insured as well as for the insurer? And it's going to be the coverage counsel who are discussing that. And it should be pre-mediation, and there may need to be a separate earlier little mediation or settlement conference just to sort out the coverage issues and who's going to do what, agree on an allocation or a proration. And then maybe certain letters written, you know, Blue Ridge letters in California, for example.
I think that's a great point. So I would say from my experience, most claims actually, we deal with it's just claims person and insured, and the lawyers don't necessarily have to get involved. That's the majority of the claims. As lawyers and mediators, we see kind of that subset of claims that, you know, that get bumpy. So you've got counsel on them and all those things. But certainly when you're talking about more sophisticated insureds or more complex cases, you are going to have coverage counsel on both sides. And maybe they're internal, maybe they're external. And absolutely, they should be having those conversations because they're able to address the legal issues back and forth, because that's all coverage issues are typically, is it's the legal issues that you're going to be debating. I love your suggestion, Jean, about a mediation before the mediation. I think that if you're in a situation where you're looking for a substantial contribution from the insured, and you really have these significant coverage issues that are disputed, trying to work those out on the front end so that you can come in and have a game plan for your mediation against the plaintiff, I think is a great, great idea. I think where I see this the most really though is carrier versus carrier, right? Where the carriers can't agree on their splits, their additional insured, their contractual indemnity. And that's where I'm always surprised that we don't have the pre-mediation set. We just jump into a 50-party construction defect mediation and everyone's like, pointing the finger at everyone else. Yeah. And I'm like, feels like we should have had a little bit of a pregame on this one. So certainly think about, not only do you need to have a pre-mediation with maybe your insureds, between the insureds and the carrier to sort out some coverage issues on the front end. And again, you don't have to agree to everything. I love a good for the purposes of the mediation, right? Like, let's set these, let's agree that we're going to conduct ourselves this way for the purposes of the mediation. Let's all reserve our rights to fight about whatever else after the fact. But let's all agree, if we can get this deal done for X amount, that's great for everybody. So let's agree we're going to go do that. And then if that falls apart, we can come back into fighting later. So I love a good truce, right? For the purpose of mediation. So I think that with the policyholders is important, but definitely when you have complex coverage issues among carriers, which is like my least favorite thing, it's like fighting your cousins. If you have problems among the carriers, which happens all the time, try to mediate those in advance. And using the same mediator can be very helpful. Or maybe you pair a coverage mediator with the mediator you're going to have in the underlying case for that, because that educates everyone, right? So that pre-mediation, that carrier mediation gets the carrier much more up to speed on what the coverage issues are. So now he or she can be better prepared for how to attack the situation that's coming up, in the next couple of days. So I think that's a great idea, Jean, a really good point, that a pre-mediation or an earlier mediation of some disputes really sets up your ultimate mediation for success. That's a great comment.
Jamie, you talked about doing all of this well in advance. And I want to dive into that a little bit. What does well in advance mean? The week before, the month before, many months before? And what do you expect us as mediators to do to facilitate your being properly prepared to come to the mediation with the appropriate amount of authority, whatever that may be?
Oh, that's a great question. So again, in a perfect world, I think well in advance means that I can give you a writing and you have sufficient time to review it and call me and discuss it. So whatever that time frame is, depending on the length or the complexity of the issue, if I have a one-pager, maybe I can give it to you a few days in advance. But if it's a real chunky coverage opinion, you might need a couple of days to review it, think about it, and then we have a call. But for me personally, I really like that follow-up phone call. So I like to say, okay, I've sent you my coverage statement in advance. Let's talk about it in however many days so that we can unpack what questions you have, because I want you to be prepared. And whatever your preparation strategy is, I want you to be able to be as prepared as possible, because that can only benefit my client. I haven't seen a lot of success where I've sandbagged a mediator and that's somehow inured to my client's benefit. So that's what I would say well in advance. It depends on the complexity, but it gives the mediator time to digest it, have a call if necessary, especially if it's a mediator that is not, familiar maybe with the coverage issues or the particular issues in that jurisdiction. And, let's be honest, give them time to call a friend, right? Sometimes, I have a mediator that isn't familiar with coverage and I send him my thing and I have a conversation with him and he's like, okay, I'm going to make a couple of calls. Like, he just needs to check that I'm not blowing smoke. So give people time to do their pre-work. And I think that lays the foundation to a more chance of a successful mediation.
And what do you need from the other parties in order to work up a case appropriately for mediation so that we avoid the problem of, we've all seen it, insurance representatives coming to the mediation saying, oh my gosh, this was just sprung on me. I'm sorry, I don't have the appropriate level of authority, and everybody's frustrated. What do we need to do to prevent that?
This is an excellent point. For anyone who doesn't know this, insurance companies do not like surprises. It's just hard to react in the moment to new information. There are requirements that we have for authority levels and things that we have to put into place that are requirements. And once that's set and we get to the mediation and you're like, here's a $7 million workers' comp lien. I know I told you it was 1.2, but it's 7. This was fun. Nice to meet you. Like, I can't do anything with that at that point. So the absolute great takeaway here is that the more information that you think is critical to your case, your damage model, your great arguments, your expert testimony, the more you can get that in the hands of the defense attorney and the claims people in advance of mediation, the more likely we are able to assimilate it and be prepared. I think I might have already mentioned this to you, Jeff, but I'm surprised. The folks that I work with, we will, if we just don't get an argument, like we're like, okay, there's such a disconnect between the parties. I don't understand where this other party is coming from. My folks will just pick up the phone to the other attorney before the mediation and will just very transparently say, I don't understand. Like, I want this mediation to be successful. Here's how I'm seeing it. If you have some great case, some ace in the hole, I'm not saying show me all your cards, but show me a card that will inspire me to bring you some money. And I cannot tell you how many times we are shut down. Just will not share any information, see you at the mediation, and that's where I'm going to show you my great argument or my awesome case law and I'm like, it's too late. It's too late. And so I really would encourage folks not to do that, to really reach across the aisle. And if you've got, be somewhat transparent with what your case is and say, hey, this is why I think I have a great case. And then we are able to address it and be better prepared for the mediation. I mean, worst case scenario, we disagree with you, and then we're in the same boat, right? We don't back up the money truck to the mediation, but we didn't bring the money truck to begin with if you didn't tell us what your big case was, right? So you're no worse off if you tell us versus not telling us. So I think
yes.
Do it.
So then, Jamie, everything that goes wrong or is disappointing in a mediation is the responsibility of the mediator. So what do you recommend we as mediators do to head off those situations and make sure things are productive on the mediation day?
So I think if you're not seeing the prep in advance, I mean, if you're a couple of days out of the mediation and you don't have a statement from either party, you haven't heard from anyone, again, I know that time is limited for you all too, and you're busy going from thing to thing. But if you get, a minute, or even if you have an admin to reach out to say, hey, haven't seen anything or heard from anything on you guys on this one, where are we in the prep? And that the prep is the expectation, not the like, oh, how nice to see. But the expectation is that you guys are doing prep. You're going to come prepared. You're going to help get me prepared. I think that might be a helpful nudge, just because people are so busy and sometimes these mediations pop up on all sides. The mediations pop up and you're not as prepared as you want to be. So maybe a nudge if you're not seeing anything, or if you're just seeing one from one side. The other thing I would say, if you're seeing, and I don't know if you can share how much you see this, but I'm assuming that most of your mediation statements or whatever are just like the strongest advocacy piece of writing you've ever seen. I mean, I doubt that people are being super honest and neutral in their mediation statements to you, but if you're seeing just a complete disconnect in how people are seeing this case, maybe a little pre-call with the lawyers to say, are we ready for this mediation? Do we need that? You say the damages are a gajillion dollars. You say you haven't seen a single thing on damages. Do we need to do a little something before we meet? Maybe something like that.
Makes sense.
The other thing I think that's important with preparing mediations, particularly if you're talking about coverage mediations, is being sure that you have all the right players to the party, that everyone that is supposed to be there is there, and again, has notice of what's going on and enough time to be prepared. So we talked a minute ago about the carrier versus carrier kind of stuff, and that's where I see this coming into play a lot. If you're in a complex litigation and you have, you're suing a bunch of defendants, let me promise you that those defendants all have contracts that have defense and indemnity obligations with other defendants and other parties you haven't even thought of yet. And they need to be tendering those and getting all of that stuff sorted out. Because what I'm still seeing a lot of is we show up at mediation and one of the insurers is like, oh no, it's not me, it's such and such insurer, and we haven't tendered to them yet, or we tendered to them a month, 3 months ago and haven't heard back from them yet, but they're not here, but they're the culpable party, so we don't have any money. And you're like, okay, that would have been great information for everyone to have when we set this mediation up. So being sure that you're prepared, that you've got everybody there that's supposed to be there. If you think another party is supposed to pick you up, let's be sure that they're at the mediation, and that you've given them enough time to be prepared, like we said, so that they can get their insurance ducks in a row and have the appropriate authority. So having the right parties is really, really important. I see a lot of mediations, especially on these big complex cases, fail just because you don't have the right people there. So that's another kind of before you even get to the mediation tip, is be sure you've got all the right parties on notice. And that's excess. Think about excess carriers, think about other tendering to other defendants. Just be sure you've got all the right people in the room to resolve the case. And sometimes you got to like draw it out, right? Like if this person's going to contribute, they're tendering to this person. Sometimes you really have to sit down and take the time to be sure you've got everybody that needs to be there. So that's my other pre-game tip for mediation.
Doesn't that really circle back to the point we're making earlier about getting briefs sufficiently in advance of the mediation to bring yourself up to speed as the mediator, to have phone calls with people, to flesh out these issues, and to do a little backing and filling if necessary, if it looks like you're not on the road to success.
I think that's super important. And you guys probably, know more than I do that if we don't give you guys sufficient time to review everything, then you're not going to be able to say, oh, wait, I see that this thing is missing or this party is missing. So again, it's being sure that we're getting the relevant information to you in a good amount of time. So maybe you don't need to, drop 600-page MSJ briefing on the mediator. Maybe you just need to drill that down so that they can very quickly assess, what's going on and who should be there and who's missing. I like to give my mediators like a who's who as part of my statement. Like, here's everyone who's coming and who should be coming. And if you haven't heard from this person, we shouldn't be mediating this case, type of thing. So the other thing I'll say about who's coming to the mediation, who's coming to the party, that actually gets us to the mediation itself, is the parties attending and whether or not you should be in person or mediating over Zoom. I think there's a million different opinions on this. Absolutely, Zoom mediations are just a marvel of technology, and it makes everything so much more efficient and it's easier to get to and to do. And I think that they're great. But I do think that for some cases, they really need to be in person. And that can be for a number of different reasons. it could be that you really need to get people's attention, maybe in one case. Maybe the clients aren't focused on the litigation or the lawyer's not really focused on it. If you think that you have a case where you really need everybody in a room, then you really need to fight for that. I think what we know now, the difference that a meeting can have in person versus remote, because we do it all the time in other facets of our lives. And if you think that you've got a case for whatever reason that it needs to be in person, then I would definitely recommend that you fight for that. And for my insurer friends, I know that, we want to try and do Zoom mediations. Sometimes the flight schedule is awful, but there are some mediations that just out of human decency, you should attend in person, because of the injuries or the people that were injured or things like that, where just if everyone is showing up in person and you're the only one that isn't there in person, might set the tone to start it off on a bad mediation. Now, there might be a reason you can't get there, or maybe it's really not necessary for you to be there, but just think about from all perspectives, whether or not an in-person mediation is what you need for this.
Jamie,
The other thing yeah.
Before we leave that subject, if I may, please, can you think of a specific example in your experience where you had a choice of being online or in person and you made a decision to be in person and it really paid off or backfired?
Yes. So I can think of many situations where I attended in person or someone from the insurance company attended in person, and having that personal connection and being able to say, hey, this is so-and-so from New York. They came all the way to Texas for this mediation today because this case is very important to us. And I have heard in the feedback after the mediation that the plaintiff themselves, the claimant themselves, even the plaintiff's attorneys, sometimes were very grateful because sometimes you feel like, especially I would imagine if you're a plaintiff or a claimant, you're so far removed from this insurance company, right? It's not your insurance company. It's just this like nebulous body that is controlling how much money you get at the end of the day, which can probably be a little off-putting. But then you realize, oh no, that's just a human person. That's just a human person, and their job is to handle this claim, and here are the reasons why they're doing what they're doing. And it just really brings that human aspect to the mediation. So I have definitely seen it work, in that way. And, I've, on the flip side, I've been in situations where people did not want to attend, a mediation in person, and, where these parents had lost a child. And I'm like, what? You're going to be on your computer and be like, sorry for your loss. I mean, come on. Like maybe we get on a plane for that. I mean, that doesn't mean that our insured did anything wrong. That doesn't mean that we're going to back up the money truck or whatever optic you're worried you're going to bring. I understand all of that. We don't want to appear too eager. We don't want to make it look like we're going to bring too much money. All of that makes sense from a negotiation standpoint, but sometimes in some cases, there's just a human aspect where you want to be like, you know what, this was a terrible tragedy, and I'm going to show up in person for you for this today. And that might be appropriate in some instances and maybe not in others, but that's kind of the stuff I would start thinking about. Is the negotiation strategy so strong that you really shouldn't attend in person if everyone else is in person? The other thing I'm saying that I would love to get y'all's perspective on, because it makes me crazy, is I am seeing this trend where plaintiffs are not bringing their clients to mediation. So if everyone's in person, client isn't attending at all. If we're on Zoom, client is not present. And I'm not even saying like available by phone. The plaintiff is saying, I have talked to my client and I have absolute authority to negotiate this case on their behalf today, and they're not even coming. I can't like express to you how much this makes me crazy, because this is the mediation is the opportunity for the client to hear all of the arguments and everything that's going on in the case and access to the client. I would think the mediator, your access to the client, is how you potentially break through, how you can potentially get to resolution. So I'd love y'all's thoughts if y'all are seeing this on this trend, because it makes me nuts.
So, Jamie, it does happen, for example, in personal injury cases where you're in Texas, we're in California, both states have large immigrant populations, people who may not speak English well or may not speak it as a first language. Unsophisticated plaintiffs in every state could be unsophisticated in the ways of business, and coming up to the 30th floor of a 50-story building might be very intimidating to people in any part of the country or any background if they're not accustomed to being in those Coliseum-like environments. Sometimes can you understand why a plaintiff might feel that it's just very reactivating and uncomfortable for them to be there? How do you deal with all of that, which might be very natural for some plaintiffs?
That is such a good perspective. No one has ever made me think of it that way before. So I really appreciate that. Those are good points. I think all of those things, though, could be dealt with. We can bring translators. We don't have to mediate in a big building. But I do understand that the situation might seem intimidating. And maybe there are valid reasons in some instances for a client. Some clients can't physically maybe even get there. I understand. But in general, I feel like a client or a claimant, a plaintiff, should be an active participant in their own case. They should be making some independent assessment and decisions about whether or not they want to settle this case, if they want to proceed with the case. And my fear is that they are not really getting the full spectrum of what this litigation looks like, what it's about. And I fear that they're not actually getting all of the opportunities to settle. And so I think that certainly there, in a lot of instances, the plaintiff's attorney is much more sophisticated and better at assimilating and understanding these things. But their job is to then explain that and to get their clients up to speed and comfortable. And I think to just say, you don't need to be a part of this process, I would disagree with that. And I think that's a mistake, unless it's a situation like you were explaining where, they really can't get there, or it really would be problematic for them to attend or participate. But it's their lawsuit, and I think they need to be an integral part of it.
Jamie, this is Jean again. I agree with you on that. And when I've been asked that question, well, do my clients need to participate or appear? I was so surprised the first time I heard that. I said, well, yes, of course. But I'll tell you of an example from, I don't know, within the last month or two anyway, time flies. A big national law firm, with the big downtown office and all, they ended up moving a mediation to a smaller satellite office, and actually closer to me, so that was great. And these folks only spoke Spanish. Well, one of them spoke English as well, but the rest of them were all Spanish speaking and involved fatalities and horrible injuries on the plaintiff's side. A translator was provided by the plaintiff counsel, and to keep them comfortable, I ended up mediating it with the various insurance carriers were all on Zoom in a conference room upstairs. I was downstairs in the lobby and outdoors where there were seating areas and, picnic table things, and mediating with two groups down there with the translator going back and forth. So they were comfortable. And there are ways, and I think even mediators should be thinking about that. It took me by surprise, and we did this on the fly on how to do it. But now I am certainly much more aware of that and would think ahead of time on something like that.
I think that's a great example of it. If it were articulated to me why a client is not comfortable attending a mediation, or, I would be more than happy to try and address those accommodations in some of the ways that you just gave in your example. But I will tell you, it has never been explained to me, not once. It's just they're not coming. So I would encourage folks that if you aren't bringing your clients to mediation, that you provide an explanation for why, because maybe there's an accommodation or a way that we can make it more comfortable for them, because certainly the mediators are amenable to that. And I think most lawyers on the other side would be too. From the mediator's perspective, do you see it as a hindrance to resolution or settlement when you're not able to speak to a party?
Almost always. Almost always.
Yeah, that's what I was thinking too. And I think obviously it's going to depend on the situation, but if clients can participate, again, I think it's their case, their suit, and they really should be a part of it if it's possible. So, but at least we finally got into a mediation. It's on all prep. We finally got to where we're actually in mediation now. The other thing what I'll say on being in a mediation and negotiating in a mediation, I will do a quick plug just to my fellow insurers. But I think this can apply to anyone who attends mediations regularly, is to give training to new people that are going to be negotiating claims on a regular basis. I think a lot of times when we're insurers, we have a maybe we don't train new people when they come in because they've come from another carrier and they kind of know what they're about. But do we really stop and ask, like, hey, how good are you at negotiation? Because it's a huge part of a claim person's job. And so I will just give a plug to the insurers to think about that. Is that something that you're looking at? Is it something that you're training on? And let me highly recommend, you guys probably have lots of books that you would recommend. I love the book Never Split the Difference by Chris Voss. I think it's very useful, just kind of baseline negotiation tactics. I will also say, if you're an excellent negotiator and you don't need it for that, it's also great parenting tips on how to negotiate and deal with your children, especially teenagers. And also it's great of just how to, how to have good social interactions and how to participate in small talk. If you're someone that struggles with any sort of social anxiety, I can sympathize, but it's just kind of like how to talk to people, get them talking, find out what they're interested in. And from a negotiation standpoint, you kind of start to find their big bets, like what they need out of this a little bit more. And you kind of keep them talking and you keep them engaged and developing a rapport. But it's also just great tips for life. So if you haven't read it, even if you're an ace negotiator, I highly recommend it. It's a great book. It talks a lot about like FBI and hostage negotiations and kidnap and ransom stuff, way bigger than we ever deal with. But sometimes talking to our kids feels like that, right? So highly recommend that book.
It is a terrific book. Jamie, we would be remiss if we didn't spend at least a minute or two soliciting your views on the opening joint session, direct communications between the sides, as opposed to the caucus-only shuttle diplomacy model of mediation. It seems to be a hot topic. What are your thoughts?
So I think I'm unpopular amongst my peers on this. I don't mind a joint session. I know that it's no longer in fashion, but I've never been cool, trendy, or in fashion. So I guess I'm just keeping with my normal personality. I think if a joint session is done appropriately and the mediator sets the expectations in advance, then I think it can be really effective. I like an opening session that isn't a dog and pony show, that is more like a meet and greet. Again, I think I mentioned, I find it effective when I can say, hey, so-and-so has flown in all the way for this. You see that your insurance company or corporate defendant or whoever is an actual person with a face and a heart and a brain and a soul. And I think that's can be very effective. If you never meet, then we're still just the insurer, right? Like, and then we're like whatever the last Hollywood movie you saw of some horrible insurance company or whatever evil corporate defendant. But if you meet the people, you realize, oh, they're just people. And I think that can be helpful. Now, certainly in all jurisdictions and all practice areas, there are personalities that we know cannot do an opening session. They just can't help themselves, right? It's going to be bombastic. It's going to be aggressive. It's going to be off-putting, and they're in the right profession. God bless them. And, but they're not opening session people, and the mediators should probably know who they are, and we just forego it. So there can be a lot of reasons not to do one. But I do like some form of it, but would love to get y'all's thoughts.
I think your views will be popular among the mediators on the line. We have just a minute or two left. Jamie, doesn't in my view, the effectiveness of the joint session depends in large part on the quality of the preparation and whether you can get people focused in on the issues where the rubber really hits the road and get people away from those bombastic courtroom style opening statements. Does that relationship make sense to you?
It definitely does. If we can agree that we're going to do a meet and greet and then we're just going to exchange on these few things. And if you have professionals that value civility, and some of us still do and some of us don't. But if you have a group of professionals that can really sit across the table and be like, look, I think we can all agree that this really comes down to these one or two things. Can we just talk that out? That might be helpful. Or if there's something that a party, particularly the plaintiff, really just needs to get off their chest, really needs to say, hey, when this happened, I really felt like you abandoned me, or, you weren't there for me when I needed you to be. Let them say those things, because I think it's cathartic for people to say that. You might need an apology, and a mediation is a great safe space, should be, for an apology that, that I'm sorry that this happened to you. Maybe it's not an apology where you can take ownership for what happened, but just saying, look, I'm a human person and what happened to you is horrible. And I am so sorry. And I'm here today to try and see what I can do to get something done for you today. I think that makes a difference, but maybe I'm still naive. I would be surprised, but maybe. I think that can make a difference sometimes if you have the right people doing it, but it's a personality driven decision, I think.
Yes, and I think you're right that the apology part of it can't appear to be for consideration. It can't appear to be, okay, I'm sorry, now will you take less money? It has to be a sincere expression of human to human interaction.
Yes, I think that's hugely important. So I completely agree with that. I think be prepared, come in with civility and professionalism, and you're going to have a much better shot than you would have otherwise.
Well, any emphasis on civility and professionalism is a good note on which to end. And our time is up, Jamie. I want to thank you on behalf of Natalie and Jean and everybody else who's here. Thank you for a really insightful, broad-ranging presentation. I hope that those who are able to contribute to the Houston Food Bank will do so, or any other food bank that's important to them. The Houston Food Bank is houstonfoodbank.org. That's houstonfoodbank.org. Jamie Carsey of Markel Insurance, this was a terrific presentation. Thank you very much. And with that, we are concluded.